with bankruptcy volumes back, we have firms that were doing 5, moving to 10 filings a month to 20, 50 to 150, depending on what the type of practice you're building. But when you're building a practice, there's certain things that would trigger an inquiry from the U.S. Trustee Program. Here with Larry Friedman, former director of the U.S. Trustee Program. And Larry, what I specifically want to know, because we're all growing our businesses right now, first time in over a decade, what are the things that would trigger this sort of like inquiry, audit, having a U.S. Trustee Program show up at your 341? What are the things that attorneys should be conscious of and say, I'm not going to do that. I'm watching this. Like, I want to get ahead of it.
As attorneys are scaling their practice, Phil, what they really should be doing is being certain that their processes are locked down tight so that there's no opportunity for sloppiness.
Mhm.
It is sloppy items that more often than not cause an inquiry from the U.S. Trustee Program.
Okay.
Rarely are there attorneys that, have practices that are inappropriate or, intentionally flaunt the rules or the code, right? The issues that the program finds that cause them to seek some remedy from you or some change in your practice have to do with your processes.
Right.
You did something in the filing of this case that caused it. You had numbers that didn't match. You had things that weren't addressed in the schedules.
Right.
And those are the things that are going to cause you angst.
So let's talk about the sloppiness. Like, what comes to mind when you think of sloppiness?
Inconsistencies in the schedules,
Okay.
for one, doing things like in a bifurcated Chapter 7, filing the pre-petition agreement, which of course gives you time, 10 days to file the post-petition agreements, but you file them 12 hours later.
Mhm.
So clearly the program is going to say, well, wait a minute, this is not an acceptable allocation of work to the time.
Mhm.
It doesn't match.
Mhm.
And those are the kinds of things that they're going to start looking at all of your bifurcated cases. And they're going to start wanting to question your debtors about these instances.
Mhm.
You need to be certain that almost from a compliance standpoint, you should seek, and we do this at Invoygo all the time, you should seek outside advice and go to the best practitioners. You know who the biggest and the best are in your districts. Go to them, ask them what they do. So, you should be hyper focused on ensuring that you are providing the best possible representation in the most compliant fashion.
And if you have staff, obviously your process need to be written out because
Yes.
sloppiness happens with staff. Oh, I got brought in someone new. They didn't do this. The natural response to U.S. Trustee Program is, well, why'd you do this? Oh, well, it was a mistake of staff. Here's our written process.
Yeah, like in any business, Phil, if you document the processes, then you have evidence that you are focused
Mhm.
and that you're intent on being compliant.
Mhm.
If it was a break in the process, that happens in business. You know this
Yeah.
from the mortgage business, the creditor business. I see it in all sides of bankruptcy. I have a large practice, Friedman Partners does, that advises and represents creditors in
Yeah.
issues they have with the
Yeah.
program and their filings of proofs of claim. Debtor attorneys know this because a lot of times they're the impetus for the issue that the program has with the creditor.
So let's talk more about these sloppiness. We talked about the bifurcation of sloppiness. You talk about sloppiness in your schedules. Can you expand on that a little bit?
Yeah, I think that if someone were to turn it around and ask you who filed the case, "Hey, let me show you this case," you'd say, "Oh, wait a minute, isn't that a problem?" Sometimes you don't. If one of the problems is you don't recognize that it's a problem.
Mhm.
So that's the first thing. You have to be familiar with the rules, the statute, and what the expectations are of the parties in this process. That's
Mhm.
number one.
Yeah.
And then you need to be sure that you have processes in place that adequately address those issues
Yeah.
so that you can point to them at any given time. That's going to be the best thing you can do
Yeah.
to ensure that if some issue does come up, you'll be able to easily explain, maybe not so easily explain, but there will be an explanation as to how it happened and you can rectify it and deal with it. And sometimes you have to be humble about it because mistakes happen. And when mistakes happen, fix them. Accept responsibility.
Regarding your first example of knowing what is right and what is wrong, we're seeing new attorneys get in the debtor world, right?
A
And
lot of them at this point.
it's hard. It's hard because they just don't know, right? So, I
Yes.
mean, clearly they don't have processes written out. They're learning as they go, right? So that's one aspect. On the aspect of the processes, for the debtor attorneys watching this, that we're doing, 3 to 5 a month, you don't have processes. You're just dealing with things as they come in, doing a different type of law. Now things are changing. You're like, wow, I could focus on debtor work, and which is very appealing because of the transactional nature, the consistency. So when you go from 5 a month to 20 a month, you're going to bring in staff, you're going to bring in paralegals. You need write down those processes like Larry's talking about so you can protect yourself and understand it yourself. How can high volume practices set up like internal compliance audit checklists that mirrors the USD program? Does USD program have anything like that, like checklists or
Sure. The USTC program has manuals,
Mhm,
just like U.S. attorneys' offices have manuals that guide them in investigation and prosecution of cases. In the U.S. trustee program, there are manuals that advise them in identifying issues with debtors,
mhm,
creditors, processes that go on in the bankruptcy system.
mhm,
And there are also guidance as to how to deal with those, both from a enforcement standpoint and other issues that are other tools that they have at their disposal. But
mhm,
the key is to remember this: the number one objective of the program is to bring people into compliance where they see non-compliance.
mhm,
So if you look at it from that standpoint, and
mhm,
if you work to satisfy them that you are in compliance and that the debtor is fully protected and not at risk,
mhm.
that's the best way.
And if you do get an inquiry from the US trustee or something like this, just be proactive about it. We record another video on that one. But this is like an important thing to be proactive and fix the process, right?
Absolutely.
Yeah. What about common mistakes for non-attorney staff? Like, what are the things that cause the trustee program, give them heartburn with regards to non-attorney staff? Anything come to mind, or is it mainly on the schedules and mainly with the attorneys?
The biggest challenge that debtor attorneys face is getting the documents and the information from their clients. And so, you need to work with your staff to make sure that they are on top of getting that information in a timely fashion.
Mhm,
And the way they can do that is they need to explain to the debtor, if I don't have this, it's going to be a problem.
mhm,
Not for me to you,
right,
but for the trustee that's overseeing your case and the US trustee. So
mhm,
I understand you're stressed. I understand these are tough times in your lives. I understand that you have a lot going on. I understand you have an ill parent you're caring for. I understand that you're out of work or you're trying to find work and all of that. But this is important. You need to do this. You need to face these issues so that we can get you the relief so you can get on to your fresh start, get these things off your plate so you can go deal with those problems. It's instilling a sense of importance in your clients so that they are reactive to you. That will be the best thing you can do.
so
That
is
helps
it,
your staff.
this is specifically for bifurcated cases, right? Not necessarily.
For every
Okay.
case.
Okay.
The biggest
The,
challenge debtor attorneys have, bifurcated, 13, 7, straight, whatever it is, the biggest challenge they have is getting the documents.
without a question, but the reason why I say it's even more important on bifurcated because you've already filed a skeletal petition,
Yes.
and you better get this
Yes.
in.
And you have a time
You got a
deadline.
time deadline,
And
right?
and and not meeting those time deadlines are gonna cause the trustee to start making inquiries, and if the trustee has to deal with your office a lot,
That
they're gonna
it's
start telling the program
Yeah, that's
that
not
you
good.
are a problem for
Yeah.
them, and then the program is gonna take a look and see if the trustee is being overly focused on you or whether or not the trustee is legitimately concerned about the kind of service that you're providing to debtors.
I think it's very interesting you bring that up because every debtor attorney knows that collecting docs is the worst. Like, it's the worst. And I have always thought about the importance of, like, the urgency with a bifurcated case because, like, we filed the case, right? But you're right. I think it's important to bring it up even when you're those that are not bifurcating. Hey, here's the situation. I understand how hard it is, but this is important for your case that you get this back to us in a certain period of time, in 7
Yes.
days, in 10
Yes.
days, because
Yes.
so much of it is loosey-goosey. I was talking to a debtor attorney recently. I mean, unbelievable. The lady signed a retainer agreement in April, made one payment for $150, nothing, no communication. I'm like, breakdown. Like, that's not profitable. Like, the
No.
attorney's losing. You gotta get the debtor motivated and keep them motivated. If they sign the retainer agreement, give you $150, in their mind, they're checked. Okay, I can wait. And I appreciate that urgency you're bringing to that.
Anything that becomes a problem, if you can't address it quickly, it's going to be a bigger problem, right? If someone's going to file a motion to compel, now the judge is going to be looking at your case,
Mhm.
right? That's never a good thing. The
Yeah,
Chapter 7 process is designed to be basically an administrative process. It should happen lickety split. Boom, you file the case. They schedule the 341 hearing within 3 weeks of the filing. Your discharge is going to be entered not within 90 days of the first scheduled
yeah,
341 hearing. And then, the complaint deadline is going to run for non-dischargeability complaints. Boom, you're out. It's
yeah.
designed to be really an administrative process.
Right.
So
Th
make sure that it moves like that.
and this is the difference between profitable bankruptcy attorneys and unprofitable bankruptcy attorneys. I mean, this is it. It's the speed to filing,
It's
like the
efficiency.
efficiencies. They get it because if you have a case that takes 2 weeks to file versus 2 months, the profitability skew is completely different. And this is
100%.
what we're seeing over and over and over. Unfortunately, this is the advantage that debtor attorneys who understand the law, who've been doing this forever, have in this market. Because you get this random guy coming in and saying, "Oh, I used to do estate planning, and now I'm going to do debtor work." I mean, complicated. But if we just lock down on systems, process, and speed to filing, urgency, keeping the debtor involved, it's a total win.
Yeah, Phil, I think that some time ago you and I chatted about this, and I'll just recall that, there was a perception long time ago that bankruptcy mills,
Mhm.
people who filed high volume, that's what they were called, high volume filers, were the problem. They were taking a lot of money and running these through a factory, and they were horrible. That was the perception when I became the director.
Mhm.
What we found when investigating these things and building civil and criminal enforcement processes is that some of the largest filers were the most compliant
Yeah,
because the only way that they could handle that kind of volume
yeah,
was by very efficient business
yeah.
processes that locked down this information.
No doubt.
It was the onesie-twosies
No doubt.
that were the problem,
Yeah.
and the onesie-twosies who scaled to 5 and 10 and then couldn't handle it were the problem. You have to have processes in place like any other business if you wanna be able to scale. That's the same for
Mm.
running a law office, running Invoygo, running any mortgage business, anything.
Well, we talk about all the time with regards to lead flow. The
Yeah.
larger firms understand the debtor, the mindset better, and they're
Yes.
taking them through this process. They convert better, more highly profitable. And, we see with these small firms, a lot of them, they relate themselves as counselors. And yes, you have to counsel your debtor. And yes, we're not talking a debtor into filing bankruptcy. They don't need it. But you don't like debtors have a hard time in making decisions. Right? Like, oh my God, you give them all this information, man, it puts them in overwhelm. And then the last thing
Yes.
you want to do is talk to an attorney again. You're probably the
Yeah.
first attorney they've ever talked to. So,
Yeah, I don't wanna give the wrong impression, but Phil, you raise a very valid point. They especially with the younger attorneys or newer attorneys in the practice, I don't mean younger by age, I mean with regard to, their experience in
mhm,
filing cases. a lot of them take the approach that, they know all of this stuff about bankruptcy, right? The debtor knows nothing, they know everything. And they want to demonstrate to the debtor in an attempt to get the debtor's confidence in them how much they know.
Yeah.
So they go in these long explanations about things that really aren't relevant to this debtor's
Yeah.
case. The debtor's eyes glaze over when that happens.
Yeah.
And when that happens, you've lost them and you've
They're
probably lost a client.
they're the
Not
anti-sales committee.
saying that you should not advise your client fully as to what's going on, but fully relative to their instances
Yeah.
and their case. That's
Yeah.
the information they need.
Yeah.
Great that you know lots about
Yeah.
bankruptcy and you've been to the last 4 NACPA seminars and spent hours in continuing legal education learning about the nuances of a cram down or non-cram down in a 13. If the debtor doesn't own a home, what do they care?
Yeah. Yeah.
Deal with the debtor, but deal with them in an efficient way so that you've addressed their issues and then move on to their cases,
Solve their problems,
solve their
speak at their
problems.
level, and
Yes.
move on and solve the case to the next debtor. Thank you for that, Larry. Larry Friedman, former director of the U.S. Trustee Program. Thanks for being on the show.
Hey, thanks for having me, Phil. Always a pleasure.